last video, I have discussed about the initiation of criminal cases, and in that video, I discussed about the initiation of criminal cases, especially those who is, which are initiated with the local police station. Now, I am going to discuss about another mode of initiation of criminal cases, that is with the court of magistrate. If a complaint petition is lodged with the court of magistrate, a criminal case may be initiated. This criminal course, locally known as cognizance course, whenever a person is refused by the police not to have lodged an FIR, or if any offense of non-cognizable have been committed against the person and property of any person, that person, that is the victim, may come to the court to file a complaint with the court of magistrate. This is the another way of initiating a criminal case, with either for cognizable offense or for non-cognizable offense, with the court of magistrate, that is cognizance. To initiate a criminal proceedings with the court of magistrate, you have to file a complaint petition. And after getting complaint petition, the magistrate will examine the complainant under section 200 of the Code of Criminal Procedure 1898. The magistrate will examine the complainant as to date, time, and place of occurrence, that is where the offense has been committed, and the person who has committed the offense, and against whom the offense has been committed. By asking this type of question, the magistrate may examine the complainant under section 200. And thereafter, if the magistrate, after examination, becomes satisfied about the commission of the offense, or if he becomes sanguine, yes, offense has been committed, in that case, the magistrate can directly take cognizance of the offense. Or after examination of the complainant under section 200 of the criminal code, if the magistrate become suspicious about the commission of the offense, in that case, the magistrate may send it for inquiry. And thereafter, after getting the inquiry report, the magistrate may take cognizance on the inquiry report against the persons named in the complaint petition, or if the inquiry report proposes to take cognizance the offense stated in the complaint petition against some other person. After taking cognizance, the magistrate may either issue summons against the accused persons or issue a warrant of arrest according to law as it is prescribed. Whenever the accused person will appear and surrender before the court, then the magistrate either may commit him to prison or may release him on bail. And thereafter, the magistrate may fix the record for framing charges. If the magistrate finds that the offense exclusively triable by the magistrate, then it may keep it under his file or may send it to the chief judicial magistrate for taking next steps. Or if the magistrate finds that the offense stated in the complaint petition is exclusively triable by the court of session, in that case, the magistrate may send it to the court of to the session judge for trial. In both the cases, if the record sent to the court of chief judicial magistrate or to the court of session judge whichever maybe the court is, that court will frame the charge against the accused. And after framing charge, the court will record the evidence produced by the complainant. After conclusion of the recording of evidence produced from the complainant, the court will fix the record for examination of the accused under section 342 of the Criminal Procedure Code 1898. At the time of examination under section 342 of the Criminal Code, the court will examine the accused by three questions. First, the court will draw the attention of the accused on the incriminating part of the evidences laid by the complainant. And thereafter, the court will ask as to the defense of the accused, under what circumstances and why he has committed the offense, if he has any explanation or not. And thereafter, the last question, the court will ask the accused whether he will produce defense witness in support of his defense. If the accused reply positive to this question, then the court will fix the next date for producing defense witness, that is DW. And after recording defense witnesses, the record will be fixed again for arguments hearing. You know, as per provision of section 265J of the Code of Criminal Procedure 1898, only the session judge may fix a record of criminal trial for arguments hearing. But if it is held by the magistrate, there is no such provision to fix the record for argument hearing. But yet that it is in practice, the magistrate could also fix the record for argument hearing. And thereafter, after argument hearing, the court will fix the record for pronouncement of a judgment. And the day of judgment, the court will pronounce the judgment in Ijlas publicly. And if the court finds the accused guilty, then the court will take him custody to suffer the imprisonment. Or if the court finds that the accused are not guilty, in that case, the accused may get acquitted. And if the convict, after delivery of judgment, if the accused is if the convict person is agreed with the conviction and sentence of the court, then it may prefer an appeal to the higher courts. If we analyze the whole trial proceedings, then we can divide it into three: pre-trial proceedings, trial, and post-trial proceedings. And a case conducted by a case which has been initiated on the complaint petition. The pre-trial states includes the filing of the complaint, thereafter examination of the complainant and taking cognizance, or sometimes may send it for inquiry and submission of inquiry report. All these are the pre-trial stages of a case instituted upon a complaint. And thereafter, all other process, such as framing charge, recording evidence, examination of accused, framing, fixing for arguments hearing, delivering of judgments, all are same like the cases which originally instituted upon FIR or HR. This is the trial stage. That is, starts from framing of charge, recording of evidence, examination under section 342 of the accused, arguments hearing, and pronouncement of judgment. And thereafter, post-trial proceeding. Post-trial proceeding includes preferring appeal to the higher court or realization of fine by the trial court, These are the post-trial proceedings. So, hello, viewers, those who have interest in Bangladesh judiciary. I am making some video for those persons for to have better understanding as to the trial and initiation of criminal proceedings in Bangladesh. Thank you for watching this video. You know, we are conducting bar profession training course. If you are a Bangladeshi national and wants to be a good advocate, efficient advocate, you can join us to be an efficient advocate within shortest possible time, especially those who are living in abroad and doing bar at law. Those person also may sit to us for doing the bar professional training course. Thank you again for watching this video on behalf of Badullah Academy.